screen, Folabi, and take
Yeah,
over.
we start 2 o'clock. 2 o'clock. I'm mindful.
Right.
We have a
great.
Good afternoon, everyone. Good afternoon and welcome to day 5, the final day of the MBA, Nigerian Bar Association Institute of Continuing Legal Education training, organized training on employment law. First, let me thank all the participants for being part from when we started last week. We've had 4 sessions. Today is the final sessions, and what we intend to do is follow the same pattern as we've had in the previous sessions, and with a little tweak that would allow participants to also at some point come in and unmute and say 1 or 2 things, maybe in form of questions, comments, observations to the session so far, and in particular the session today. So in addition to leaving your thoughts and comments and questions in the chat box, at a point would ask that you can be part of us. But in the meantime, let's start what today's session is all about. Now, today's session, interestingly, is just as the previous sessions, and looking at pointed areas of concern in employment law vis-a-vis the court system, where we go to ventilate or litigate causes relating to employment and employment law and industrial dispute. Today's session deals basically with one interesting area, which I like to sum up this way. The justice delivery system in itself generally discourages stale claims from being brought and invariably long gestating on the court's docket to add to an already overworked system. So, thoughtfully, there have been legislative interventions from time immemorial, stipulating timelines and time limits for prospective litigants to approach the court to ventilate their cause. And the legislative effort in this regard, the Statute of Limitation of Actions Act, and in some sectors, the Public Officers Protection Act and related statutes or laws of that nature, basically stipulate timelines for bringing an action when there's a complaint in relation to just about anything. So, for example, it stipulates a timeline of 3 to 4 years for an action relating to thoughts, complaint relating to thoughts, 6 years for contract, 12 years for enforcement of action and enforcement of judgments and land-related matters, and so on and so forth. Now, for POPA, which is the one, that is Public Officers Protection Act, which is the one that seeks to protect the public officers, the time one can approach the court to make a complaint in relation to an act or mission of a public officer. There's a strict timeline of 3 months or 90 days. Now, that's on the one hand. I mean, that's looking strictly from the formal courts. I mean, looking at the way the law is interpreted strictly at the formal court. And then when I say at the formal court, let me condescend to the particular court, the judex that we take employment matters to. Now, we'd all recall that by the spirit and intent of his establishment statute, the National Industrial Court was designed to be a court of less formalistic, less rigid procedure and approach in the practice and procedure of the courts. And of course, little wonder why, for example, you have a provision such as Section 12 of the Establishment Statute, providing that the Evidence Act, which we all know is an adjectival law that strictly prescribe how plenary hearings are conducted, can be dispensed with in very deserving cases. And this has been subject matter of judicial decisions. And with the most recent, or I mean, the more compelling ones agreeing that that position is correct and that the industrial court indeed has that power. Now, we take a step further to look at instances where the court system has also been faced with situations or arguments as to whether indeed the stipulation as to stale claims, not long gestating and could be brought at any time, would apply in that court. And this has often come in the appearance of objections relating to actions being filed, actions pending in court at the industrial court, and objection being raised to those actions that by the nature of the complaints, this should have been brought within 3 months. Usually, most of the actions against public officers or governmental agencies, or that by the nature of the complaint, it relates to contract. And because it relates to contract, the accrual of action in itself, well over 6 years ago, and it's just been brought now, and then the court should dismiss such an action, because the law is that once an action is caught by time, it is not striking out that follows, it is dismissal, because once it's caught by time, it cannot be made well to fit in the court system in the future. It is just caught by time, it's caught by time, and it should be dismissed. So there's been some controversy around, particularly in this area, and the controversy has been whether indeed the industrial court is endowed with the power following judicial intervention from the appellate court, the holdings from the Court of Appeal, from the Supreme Court, whether indeed actions related to contract of employment are designed to be caught by time. Actions relating to contract of employment, whether indeed the law intends or the judicial holding is that indeed it should be brought within a particular time, or it can be brought in perpetuity. Just speaking, putting it lightly there. So that has been on for quite some time. And we just thought that it's important that we look at it, because as of today, the truth in itself is that if there's anything that is certain in that area, it is that that state of the law is a little bit uncertain. And there's a need to interrogate a little further to understand what this is all about. So it is in this regard that we thought that we should bring a colleague, thankfully a thought leader in this area of labor and employment law, so to come facilitate this session and come tell us what the position of the law is, can or should be, with regard to statute of limitation in private employment law. So, ladies and gentlemen, it's not my show. Without much ado, I would ask that we invite to come and facilitate this session Mr. Taiwo Adesina, who is a partner in Jackson 80 Hedu. Mr. Taiwo Adesina, if I'm just, and has a very intimidating profile, and I would not speak so much to it. I know that it will give a good account of that profile, which we would also share. And I think it's part of what was shared in sharing a few things about this in the publicity document shared about this particular session. Taiwo heads the corporate commercial department of Jackson 80 Edo and the energy and infrastructure sector. His expertise is in labor and employment matters is born out of a strong dispute resolution background, combined with a rare understanding of the current labor law and employment landscape in Nigeria, as well as international best practices. That's interesting. And I think I should leave it at this and let him come. That is intimidating enough and gives us an assurance that this is an area that you'll be able to do justice to. Taiwo, please, you have the floor. Thank you very much.
Thank you very much, Learned Silk. When you said I have an intimidating profile, I was wondering if there's anything near your own, but I take it as a compliment. Thank you very much for that introduction. Am I audible?
Loud and clear, loud and clear.
Great. Thank you very much. And when you were speaking, I was listening very attentively, and it was as if you read my mind, because when I saw the topic, it was actually indicated as statutes of limitation in private employment contracts. As I was going through the topic, I thought that it would not be complete if we don't look at it from the point of public employment, right? Which is what Learned Silk has just spoken about when he mentioned pauper, right? So without wasting too much time, we just take a straight dive into it. So as we get along, you won't see, or I've modified the topic to read statutes of limitation in employment contracts. So you probably won't see private employment again. It will just be employment contracts going forward. So this paper is basically an overview of the statutes of limitation and their application to employment contract vis-a-vis the Supreme Court decisions, in National Revenue Mobilization Allocation and Fiscal Commission versus Ajibola and Johnson and others, and subsequent decisions of the Supreme Court now being followed by National Industrial Court of Nigeria. You would understand when we get into the presentation proper what we meant by several decisions or subsequent decisions of Supreme Court on this time limitation concerning employment contracts, as well as what NIC has done, pursuant to those decisions. So in this discussion, we'll be looking at statute of limitation. What exactly are we talking about? We'll be looking at the purpose and effect of statute of limitation. Essentially, on purpose, we are looking at speedy dispensation of matters that are brought before court at a point where the evidence is still very, very fresh and the witnesses can't remember vividly what they are attesting to before the court. Remember, these witnesses are on oath. And also what happens if those actions are not brought within the time stipulated by the law. What has become of those actions? Learned Silk mentioned dismissal is proper order to give. So we'll talk about that a little bit. We'll also look at instances where period of time to bring an action will stop to count or frozen because of certain scenarios. When we get to that part, we'll speak about this, something like maybe mediation. If there's a mediation in between the commencement of an action, does time run or does it stop at the beginning of the mediation and then resume after mediation would have been concluded? We will look into that amongst others. Also, computation of time. How is time computed with regards to limitation period? There are people who would say it is when the cause of action occurs. Some will say it is when the plaintiff becomes aware of the particular cause of action. And some will say what happens in the case where the action is continuous. We will speak to that and probably have a learning as to the appropriate way to look at these various scenarios and what to do in terms of limitation period and how to calculate that. We'll also look at instances of limitation periods in Nigeria. At that point, we probably will drift slightly out of employment contract and mention just a few around it. Learned Silk mentioned thoughts when he spoke. There are other scenarios that we'll just touch on just to give us a general overview of limitation law or limitation periods in certain courses of action. And it's important to say at this point also that when you are looking at limitation of action, you may have to look at the relevant place where the action is being brought. So for instance, you have limitation law of Lagos State. Most of the things I will be looking at here, or examples that we'll make here, will be relating to limitation law of Lagos State, but each state has their limitation law, and including Abuja that has limitation act. Abuja, you're looking at the act. If you're in the state, you're looking at the various limitation laws of the respective states. How do you determine when an action is statute bad? What are the components? What are the elements that you need to look at to determine that? We'll discuss that briefly as well as statute of limitation in employment contracts, which is the crux of this paper, really. So we'll look at that vis-a-vis between private employment as well as public employment and what the landing is, or what is playing out in court at this moment. And then we zero in on POPA. POPA is Public Officers Protection Act against state limitation laws on contracts. Of course, employment contract is a subset of contracts, so that will speak to that. So now proper to the paper, it is not in doubt that people do have right of action in court, which are usually predicated or premised on causes of action. What then is a cause of action? As of today, those are aggregate of facts, right, that if proven by a plaintiff would entitle that plaintiff to a relief or some reliefs. It's important to know that when you have a cause of action, before you bring forward those suits, you need to check as a diligent lawyer to check what the elements are of that particular cause of action. So for instance, if the cause of action is a breach of contract, you want to be sure that all the elements of contracts are available or are present in your case before you proceed to court. That's on your cause of action. If it's on negligence, you want to know that all the elements of negligence are present. Contract, so you'll be looking at parties, capacity of parties, offer acceptance, intention to create legal relations, amongst others. And then for negligence, of course, is duty of care, the standard of the care, and the breach of that standard. If you have all of that in the elements of your cause of action, then you can then proceed to court. But as you are proceeding to court also, you want to be sure that you are not caught by the exceptions to those particular elements. If you are caught by those exceptions, then there's really no point. And after that, which is your cause of action, is your right of action. If your cause of action is established, then you can proceed to court to file your action. And this is where limitation of actions come in. As at the time you are going to court, if for any reason you are caught or you are statute barred, that action or that particular cause of action is statute barred, then it makes no sense, really. It will be dead on arrival. What needs to see is that the partner side different in this case. We just put in a personal rejection, asking the court to dismiss your matter for want of limitation of action point, which basically is saying that, look, you are statute barred, you can't bring this action again. Time has elapsed within which you are allowed to bring that action. What is a statute of limitation? So by definition, Black's law, as well as the case of NNPC and MLK, both define limitation of action to mean a statute of limitation in any statute prescribing limitations to the right of action on certain described causes of action, that is, declaring that no suit shall be maintained on such causes of action unless brought within a specified period after the rights accrued. Unless brought within a specified period after the right accrued. Remember when I spoke earlier, I did mention that is it when the cause of action occurs, or is it when the plaintiff becomes aware and in a situation of continuous cause of action? When do you, how do you determine when your time starts to count? We'll get to that in a bit. So this slide basically is on the purpose and effect. I think we've spoken about this a bit. The essence is to ensure that matters are resolved in good time while evidence is still reasonably fresh and available. And the effect is that if you don't bring those matters within that time, your case is likely to be dismissed and will be dismissed, really, if you are bringing it out of the time stipulated for you to initiate such action or actions, as the case may be. Yes, so the next point to be discussed here is whether or not time can be frozen, for purpose of limitation of action, or your matter can be the time for it within which for you to bring an action can be suspended and probably later for purpose of limitation of action. And the answer is yes, there are instances that can happen. I did mention earlier on that if mediation proceedings ensue, then the time for that mediation proceeding will be excused from the period within which you are expected to bring such action. And that is provided for in the Arbitration and Mediation Act of 2023. The other instance is a situation where you have a civil or criminal case against persons in office, political office, elected political office. You may not be able to bring that action while they're in office because they enjoy immunity under Section 308. And the essence of that basically is to allow them to focus on the function of that office. That is not to say that actions or those actions cannot be brought against those persons after they would have left office. In situations where the term of that office is renewed by re-election, that time is still available for you to bring that action after the second term would have elapsed. So you are really not losing anything. It's just that you cannot distort the person's obligation to perform in that office during the time that they are in office. So that is called immunity under Section 308 for those persons, and they are president, vice president, governors, and deputy governors. So on this suspension, I think what is important also to discuss, and I've seen this severally in my years of practice, is situations where you then have very tactical businessmen who understand the court processes and they know their onions, would engage you, when there's an issue, they engage you, start discussing possible settlement or negotiation of settlements of that particular dispute. And what they are doing in essence is just to while away time. They would even go as far as probably providing draft settlement agreements or draft settlement agreement, and you just realize that to put pen to that paper will be difficult. It's back and forth, and all they are waiting for is for time to elapse. So in essence, if you have any cause of action or your client has a cause of action, the best thing to do is kick it in, file your suit, and then you can engage on negotiation, because negotiations does not stop time from running. So what should be at the back of your mind at that point is that, look, we can always settle, whether at trial court, appeal court, or at the apex court. Settlement can be done at any time before judgment. So that does not stop you from filing action, and it shouldn't stop you. If you do that, it will be at the risk of yourself or of your client. So it's important that we just mention that. So the next one, and I think I touched on this briefly earlier on, is how is time the purpose of limitation period. I mentioned that the general principle is date of occurrence of the event. That's typically what would happen. But there are instances where beyond that, it could also be when the plaintiff becomes aware of the facts of the case. So, for example, adverse possession of title to land, for instance, is a case. It is when that plaintiff becomes aware that somebody else is claiming title to his land, not necessarily when the person went on the land or started building on the land or has taken possession of the land. But when he became aware, what has he done? He has to act within from that period to like 12 years if you're talking about Lagos State. But we'll come to that in a bit because it's a different regime if you are proceeding against a state authority on title to land. Yes, so the third of that, and there may be more, is the continuous. How do you determine when your time starts to run? I believe, and I know that based on some judicial decisions, it is when that continuous action ceases to happen, that is when that time starts to run. So the case of Fulani and Augusto is very relevant in that on that point. So I did mention that we'll touch on some examples and that we might just drift slightly out of contracts and, of course, employment contracts. So one of them is simple contracts. Generally, is 6 years in motor. It's very important that depending on where you're filing, check very well what the limitation period is as you engage or as you assist your client to ventilate their issues in court. Also, negligence, I think, is 3 years. So you know that if it happens, you have 3 years to pursue that claim. Also, on claims premised on Employee Compensation Act, if a decision is made by the NSITF board and you want a review of that decision, you have 180 days to do it. Otherwise, you are not able to go to that particular board for review. Your option maybe to go to NIC as by way of appeal. So this was the point I mentioned earlier on. Another instance is recovery of land. For states, in Lagos State is 20 years, but for other individuals, it is 12 years. So you have 12 years to bring your claim. Otherwise, it becomes statute barred. Don't forget I mentioned that if you're talking about adverse possession, then that 12 years will start to run from the day you became aware of the adverse possessor. Yes, so the next is action against public officers. So I'll say this at this point on a general note, then we come to contract. So on a general note, actions or acts of the public officer that is done or carried out in the course of his performance of his job or his obligations in office would be statute barred if you don't bring that action within 3 months, right? But there are other views around it, and people have pushed that argument that if those decisions are made in bad faith, will the 3 months protect the public officer and his office? That is another matter entirely, right? And also, there's also the issue as to whether or not that protection would avail that public officer or office if the matter strictly is on contracts. But we'll come to that when we discuss employment, limitation of action on employment contracts in public office or against public employer. So I think 2 other points to note here is the fact that you could have series of causes of action in a particular case or exist in an aggregate of facts. So for instance, you could have like negligence as well as breach of contract of employment, all in a set of facts. And you probably want to look at that and at least do a diagnosis of it to know whether or not one is statute barred, and then you know how to proceed. We all know the jurisprudence around principal cause of action and subsidiary. So if you are very clear on which one is still alive, then you know what to go for. Otherwise, you may be shut out. And the second one is that I mentioned that states may have different limitation period or causes of action. So you need to check very, very well, although most of them are similar. So how do you determine, or how do courts determine when an action is statute barred? What the court will be looking at first is you need to know how to put those things down in your pleadings very well. The court is going to be looking at when the cause of action arose. The court will also look at when your action is filed at the registry of that relevant court. And then in between the two is the time frame within which you are required to file those actions. And once those are ascertained, the court at a glance can tell whether or not your matter is statute barred. So it's very important that you are clear on this requirement and your pleadings are properly worded to ensure that you are not barred from prosecuting your claims. Yes, so this is now limitation of actions arising from employment, the crux of what we've been discussing. For most states, employment contract is an offshoot of a contract and the seat are same. So they'll be looking at 6 years as your limitation period. However, and before now, the general rule, when it comes to same employment claim against a public office, the chances are that, and those were the position at the time, the chances are that you would have to do it within 3 months. Otherwise, the POPA, which is the Public Officers Protection Act, would kick in or will be pleaded by the public office to dismiss your claim. This is exactly what I just mentioned in the previous slide, but with Prime Service Commission, that will tell you what the position was before now. But going forward, we are not going to just oppose the developments around the application of POPA to statute of limitation to employment claims brought by the plaintiff against a public office. So 2019 was the first turning point that changed that narrative. In 2019, the case of Ajibola Johnson, and that's on page 70, paragraph F of the judgment, the Supreme Court held that Section 2A, which is the protection that public officers usually seek, that's the provision under which they seek protection, does not apply. The court said that it does not apply to cases of contract. In this case, the respondent claim is on a contract of service, thus the appellants are not covered by the provisions of the Public Officer Protection Act. What had happened, amongst other issues in that particular case, was a situation where the Revenue Regulation Allocation and Fiscal Commission employed a number of people. Those guys accepted the offer of employment, and by so doing, a contract was formed. And then after a while, because of change in government, there was a directive that the employment that were done within certain period should be withdrawn. So they wrote to those guys and said they were withdrawing their offer of employment after they had resumed. So that was the genesis of that matter. Of course, there were other issues that came out of that matter, particularly on whether or not they should be paid, till the end of the hearing of that matter or determination of the matter. But all of it, what is important for us is that the court said, look, you cannot rely on Section 2A of POPA to protect the office on the action taken, which is the withdrawal of that employment letter, and that what would apply is general contracts law and the statutory limitation for bringing a course of action under contract, which is 6 years. So that brought about a change in the narrative of what happens in public office for breach of employment contracts on time limitation. So this I had mentioned, it was what changed the position at the time in 2019. But barely 2 years after that decision of Ajibola Johnson, or in Ajibola Johnson, rendered by the Supreme Court, the same court flipped over and then held in Idachaba's case that the POPA would apply to contracts. And then that was when it now became so unclear as to which do we follow. Just 2 years after that, a new scenario, a new judgment on the same issue of employment contract stated that, look, POPA would apply and stand to protect the public office or public employer, as the case may be. Then that was 2019. 2 months after that, we had another Supreme Court judgment. This was on Rahmaniya United Limited. That was Minister of FCT and others. And interestingly, this case, the subject matter of the case was on recovery of title to land, right? And same with the case of Obasanjo and another versus Uroboga Limited. It was also a case bordering on land title, right, or title to land. And Supreme Court, by way of an obiter, if I may use that word, because it wasn't the real issue at hand, it was just title, mentioned or stated that POPA will not apply to actions for recovery of land, breach of contract, or claims for work and labor done, right? But because of the weight that's usually attributed to the decisions of Supreme Court, even though it wasn't the focal point of the issue at hand, it became like a decision as well. And what then happened after that was the National Industrial Court citing those authorities, albeit that it was on land matters, but because the court said and mentioned that POPA will not apply to employment contract and general contract as well as land matters, they cite it and use it. The Ismaila case, which was very, very recent and as recent as 13th of June, 2023. In that case, NIC noted that the Idachaba case heavily relied on by the defense counsel, but opined that by virtue of the Ramaniya and Obasanjo cases, employment contracts are not caught by the limitation period in the POPA. Note that I said that this wasn't the crux of that matter. The facts in issue in those cases were pure recovery to title to land. But because the Supreme Court mentioned and stated that POPA will not apply to land matters, right, recovery of title and contracts, and of course, labor related issues, the NIC in this judgment in June relied on that and followed same as the rule. It would then appear that as we speak today, being the most recent decision from NIC, the chances are that the court has reverted to the Ajibola Johnson's case, and that's probably the position that they will hold. However, by way of conclusion, if I'm to advise, because of the uncertainty around which law would apply, is it POPA for employment that's related to public employer, or will it be the natural limitation laws of the relevant states? We would advise that if you have the time, put in that application or put in that suit, file that suit, right, within 3 months. And what that does for you is that it has bought you like 10 years, you know, of unnecessary litigation of somebody for nuisance value, going all the way from court of first instance all the way to Supreme Court, just to come back and say, look, okay, they are not protected, before you then go straight into the substantive action. So I would say if public employer is involved, do it, even though you have 6 years as of today. Put in your within 3 months, and then you can proceed. That would be the wise thing to do as of today. And that is based on the fact that the decisions relied on by NIC, which is the latest one, are not the crux of those cases. The crux of those cases were on title. The Supreme just mentioned by the way that it doesn't apply to recovery of title, and then went on to mention contracts, right? So by way of question, the apex court position in Ajibola's case was reversed. We said that earlier on. The position in the Ajibola's case appears to have been reversed also. The reason why I use what appears to have been revised is because it wasn't the crux of that matter in Ramania and Obasanjo's cases. These two cases have now been followed by NIC in the recent case of Ismaila Oluwatosin Dizali and 19 others versus National Pension Commission and other. In that wise, my advice, as I've said earlier on, even though the position looks like, look, for both employers, for both employment by a public employer and private employer, the statute of limitation or the period of limitation to bring an action appears to be 6 years based on where we stand today, right? I would advise that when a public employer is in your claim within 3 months, and then avoid the unnecessary litigation of going all the way to ascertain whether or not POPA would apply. And I think that brings me to the end of this presentation. Thank you very much for listening.
Thank you very much for what I would call a well-researched and well-delivered lecture. And because indeed, listening to you, you commendably went even outside the remit of what it would appear to be the limiting to speak to or address on, which is statutes of limitation as applicable to. You were gracious enough to let us know about cause of action. You were gracious enough to let us know as it applies across board in other areas, and even to public employment. And indeed, there's a lot that I can do taken away today listening to you, and I have no doubt that the other participants also. And so it will be time for questions, but I think if you allow me, let me just start with my own few observations in some of those things that you've said. I agree largely with most of what you've said. I think my observation will just relate to about three areas, comments. The first is where you mentioned that time can and will be frozen in mediation arbitration matters. Indeed, I agree that if we were to look at the letters of the extant arbitration law, Arbitration Act, I mean the 2023 Act, that has been made express. But before now, or let me say the states of judicial statement on same, because we're a judicial statement validating that, the state of judicial statement on same, and up to the Supreme Court, which is the city engineering case, is that time will continue to count even once you're going to arbitration. So if it's contract and it's 6 years, and you have to submit to an alternative dispute resolution mechanism as parties had envisaged and put in their contract, time will continue to run. That's a 1997 Supreme Court city engineering case, and federal versus Federal Housing Authority, which I'm not aware has been overruled. But of course, if the facts part of, in the light of the new law, were to get to the court, there's no doubt that that will be the position. Then it would appear also, so moving away from that, I think it's important to also make some slight variation or distinction with reference to those cases that the industrial court seem to have followed either religiously or almost to the point of having inconsistent holding or not being very clear which to follow. And my personal take on it is that I do not think it's more of the court, if it's more of the court being tied to the principle of stare decisis, I mean judicial precedent, following what is the latest position on the point. And to that extent, I perhaps want to excuse and go straight to the highest courts of the land to say a lot of the problems were originally, they came from the court. Now, you beautifully identify the 2018 decision of the Supreme Court in National Revenue Mobilization and Fiscal Commission, Ajibola Johnson, where, I mean, the court had said that it will not apply. Now, one interesting thing about that decision is that, yes, it came in 2018, but it is a decision that took time to examine an earlier position of the Supreme Court made as far back as 1974. Construzioni is an Italian name, a Nigerian port authority, where all of those things were beautifully elucidated, and then came to the conclusion that when it comes to contract, it will not apply. And that had been on for a while. Now, the state of flux, like I say, that I would rather want to blame on the Supreme Court. In Dachaba's case, which in your conclusion you would seem to suggest or seem to say that has overruled Ajibola, because Dachaba came in 2021, Dachaba and Federal, as investor of Agriculture Makodi, came in 2021 and said that it would apply, is a decision that I do not agree has overruled Ajibola Johnson for the singular reason that, for the simple reason that if you bother to go through Idachaba, there is nowhere that there was a reference to the decision of the Supreme Court in Ajibola Johnson. Idachaba did not make reference, not a single reference. And before, I mean, our understanding is that before you can say a case has overruled an earlier position of the Supreme Court or the Court of Appeal, I mean, that earlier decision must have been frontally discussed or brought to the attention of the latter panel in this present decision. So that was not discussed. at all. So to that extent, I would say that that invariably leaves the lower courts in a state of flux. If you are to follow, again, what judicial president says, that they may probably be able to choose. And again, some suspect position says that it is the latter that you follow. But let's leave that for one moment. Now, Idachaba, as you said, was 2021. The interesting thing is that Idachaba being followed by the Court of Appeal was only followed in a case in 2022. And since Court of Appeal is the final court of the industrial court, Court of Appeal is the final court. So in Okojaja's case, which came in 2022, Okojaja followed religiously Idachaba. So again, that might probably create a state of flux in the sense that if the industrial court were to look at the final court for matters emanating from it, the final court's position, that is the Okojaja's case of 2021, is that it is Idachaba that is the current position of the law. And to that extent, it would appear as if, yes, it will not apply. That when it comes to contract of employment, it would apply. I'm sorry to say that.
Yes.
It will never apply because Ajibola said it will not apply. Now, but going further, the latter decisions, which you have said that in recent decisions of the industrial court, they seem to have followed the Ramaniya Basanjo line of cases. Yes, the central crux in those matters might not have pointedly be contract, but it is arguably a ratio from those cases because Supreme Court said in one of those two cases that it would apply to contracts. So, and I suspect that that is the reason that it will not apply. It does not apply to breach of contract or claims for work and labor done. So because that was said that it will not apply, then you can imagine the industrial court also falling back. What is important in this discussion is that it's important to get a fine position from the appellate courts. The industrial court is a court of first instance. For there to be clarity in this position, this present state of flux, there must be a clear statement from the appellate court. So it would appear that there's such a stage for, the court sitting almost like a full court to review the position in all these cases and then make a position that the industrial court, that can guide the industrial court as to whether indeed statute of limitation, whether it is proper or any shape or other form in which it comes, but the whole intent is to limit time within which an action can be filed. When it comes to breach of contractual obligation, it would be clear that this is the position, whether it would apply or it will not apply. So, that is the way I would probably think that is the answer. The state of flux as we have presently is that you have 2 or 3 decisions of the Supreme Court saying inconsistent, mutually contradictory holdings. And in the latter decision, the former decision was not discussed at all. And if you follow strictly what judicial precedent, the principle behind it, that cannot be said to have overruled it. So I would leave it open now, and then I see that there's a lot of questions that may.
Leonard Silk.
We have a couple of questions and answers, and which
Leonard Silk, I don't know whether you can hear me.
Yes, please go ahead, sir. Please go ahead.
Yeah, thank you so much. Good to see your face again after a long time.
Thank you so much. Yeah, good day.
Yeah, I also want to commend Taiwo for a beautiful job, and it's very, very informative and well-researched work.
Yes.
What I want to just chip in is that I come across the decision by the President of the National Industrial Court, my Lord Justice Kanyi.
Yes.
Decided just 25th of last month, 25th of July. Yes. That is the case of Gode Esezobo of Banoike against National Drug Law Enforcement Agency, yes. Suit number NICN ABJ 77 of 2023.
Correct.
So, because I don't know how to put it, but my Lord has the way developments that have happened in National Industrial Court have been basically case law, and my lord has been very instrumental in those developments. And his opinion or views carry a whole lot of weight. In that decision, what the cases he relied on were the Edashaba case, and then Abdul Rahman and NNPC. And he came to the conclusion that these decisions were followed by a third fund against Abdul Rahman in 2022, and that in view of that, that NIC is bound to follow the decisions of Edashaba and the NNPC, the third fund case. The reasoning of the court is that why Ajibola Johnson was clear that limitation will no longer apply, that the subsequent decisions of the court, that the position being that the later decisions should prevail, that the court was bound to follow those decisions. And my lord followed that decision. And I find it refreshing. I agree with you completely that there are still confusion because of the other decisions that came after Edashaba. But I find it refreshing that at least the NIC have taken this position. In recent cases, just last month, in a matter before Justice Sowe, Uwegbu against Lakasela, my lord refused to apply Edashaba and also relied on Ajibola Johnson to say, held the same position that limitation does not apply. Before that time, before Justice ACM, there are a whole lot of cases coming up, and there is need for clarity for people to be able to understand that this has now become the position. If we can't get that clarity from the Supreme Court, it's worrisome. And the reason why it is worrisome is that most of those cases do not really pertain to the everyday employment disputes. And that is why I believe that Edashaba is more clearer and more closer to the issues of limitation on whether it should apply to employment contracts or not. And I want to believe that maybe in view of the decision of my lord, the president of the court, that more judges of the National Industrial Court will be more amenable now to listen to issues of limitation. And I think it should apply. And the reason is this: if you look at the philosophy behind limitation, I'm dealing with a case where somebody is filing a matter against the bank after 20 years. Almost everybody who was involved in that transaction, who knew anything about that case, has long gone. And in one of these similar trainings we had, where the judges of National Industrial Court were involved, a question was posed to my lord, Justice Kanyip again, about this issue of why we will allow that length of time. In some cases, the time that has passed is so much that the employer will not reasonably expect that the employee will bring an action at that point. My lord explained that why, as of that time, the National Industrial Court will not countenance applications or objections based on limitation of time, but that the court will look at laches and acquiescence. That if in your pleading, you make it an issue that so much time has passed that this action could not be reasonable, be expected to be ventilated at that point in time, that the court will look at it from that point. But I'm happy that the court have also said now that maybe it can consider it as an issue of limitation, because I think it is something that the court should apply, because it is not really punitive. Limitation is not punitive. It is intended to ensure that when you have an issue to ventilate, you do so timeously and get it done with. Thank you very much, sir.
Okay, very beautiful. Yes.
Yes, just to mention that the chairman of the MBSULE is online, and I would like to say one or two things.
Oh, please, the able and capable DG of the Institute of Continuing Legal Education. I mean, all we can say is thank you for keeping this conversation going, and then the conversation being across board, and it could be energy law today, employment law tomorrow. I mean, there are lots to be said, and to just continue to say thank you that, I mean, we have this, and then please, you have the floor, please go ahead.
My brother Falabi, Leonard, the Advocate of Nigeria, thank you. I think Taiwo was trying to say something. I think he was trying to exercise his right of reply.
It would have it. He would have it. He would have it.
Do we want him to go ahead so that we don't lose the flow? I can come back right away.
Okay. No. I agree with you. I agree with you. And that's most thoughts in response to but please, Taiwo, please go ahead. It's going to be interactive. A lot more persons will be allowed to please come in on mute and
let's take Kolabi. Kolabi, can you hear me?
Yes, please go ahead.
Okay. Before Taiwo comes in, maybe I should just chip in my bits and maybe he can take everything together.
Yes.
Okay. I am interested in an aspect of this presentation relating to contracts. So this is my understanding and my reading of the cases, those that, and Taiwo did an excellent job. Thank you very much, Taiwo. The cases that have been discussed and that have been mentioned by yourself and by others. Now, so there are, from my understanding, there are two species of limitation laws. So you have the general limitation statutes, like you have the Lagos State limitation law, statute of limitation, and then you have those that protect public officers. So, which is where the POPA comes in, the government parastatals come in, government corporations and all of that. So when I am dealing with limitation of statute from a protection of public officer, I understand that that is specific and targeted at specific public officers. So it comes down to interpretation of that statute. So I don't want to go into all the conversations relating to POPA and all of that, because that goes to interpretation of the statute. I want to look at the general limitation law like that of Lagos, which puts a limitation period for ventilating contracts, suits relating to contracts. And I have been trying to understand the NIC's approach to this statute of general limitation. In my personal view, reliance on POPA and all of that to treat a claim or an action affected by the general Lagos State limitation law, for instance, I don't think they are apples and apples. I think they're apples and oranges. And so I was interested in saying, okay, if you take out POPA, you take out the specific legislations to protect public officers, how does the NIC respond to a general limitation of law like the Lagos State limitation of law? And from my reading of the case, it appears as if they fall back on policy, which is the policy of the NIC to do fairness, to do justice, to use their general powers and discretion not to allow an action to be caught by a limitation period. For instance, you have a claim, distinctions were made between claim for breach of contract, unlawful termination, wrongful termination, and then claim for salaries, benefits, which some may argue are continuous. So, but when you take out everything, it appears to me that the NIC's strongest argument is on grounds of policy, this should not apply. So I don't know if anybody else shares that view, because I've read my Lord Justice Kanye's decision, which was before the last one that he just gave but that one was a federal, so that one involved Federal Inland Revenue Service, Office of the Attorney General, office of the head office. So there was a public officer involved in that, Victor Omotosho Ekundayo, against Federal Inland Revenue. So that decision was in February of 2022. So I can understand all the argument and discussion about POPA and public officer protection now, because this was a public officer. The one I struggle with are the twin cases of Lilian Makuma and First Bank and Godson Nkume against First Bank, which are basically private employment cases. And in these cases, it was the Lagos State Statute of Limitation that was relied upon. And the courts in these cases relied on the decisions that were based on POPA and public officers protection. So that for me, there was a slight disconnect. So that's my little intervention. Thank you very much.
Thank you very much, Lenny Brother Serke and Wilson. I would, of course, it wasn't directed at me. I would ask Taiwo to give a response. But before Taiwo does, please permit me to say that I do not exactly agree that it's apple and oranges. The truth in itself is that law works and determination or resolution of dispute, I agree, it's always against the particular fact pattern. I mean, when reference or reliance is based on precedent, it must be against the particular fact pattern of the earlier decisions or the decisions of the higher court being sought to be relied upon. And I think Okuta made that very clear in Adeko Kimotus and Adesoya. But this area, it would interest you to note, Wilson SAN, that in one of the decisions, and as you ask and you elucidate further on what would appear to be the slight disconnect in relying on POPA for private employment, in one of the decisions, I was struggling to recall it, it was delivered by Honorable Justice Arowe Shabu of the Industrial Courts, Enugu Division. This pointed question was posed, and he had an opportunity to address it frontally. And I can assure that I'll make that available before the end of this, because that was situated as against actions law of Enugu. So it was a private employment issue. It was, I remember that it was the actions law. There's a law that is called actions law about in Enugu State that makes a provision for this time within which to bring an action. And he had an opportunity, I mean, commendably, that's why I don't want to, I'm very quick to refer to where I read it, not to claim the credit. He had an opportunity of examining all these cases, but more importantly, to point out that in one of the earlier Supreme Court decisions, it was said that what is POPA? There is no basic distinction from POPA seeking to protect public employees from what is contained in a law made to regulate private contracts. Because even POPA or the equivalent laws in the state recognizes in section 2, I remember that was the section referred to, that POPA is nothing but just a species of a limitation of action. And that because it has been said that is a species of a limitation of action, the general flavor can apply irrespective of whether it's private or, so, I mean, the point I just struggle to make there is that I think it goes beyond saying that it's just a policy consideration. It is perhaps situated as against the background of even what the learned justices have held in many or some of these cases that have actually been put forward. But I'm just a moderator. Let me leave that to Taiwo.
I don't know whether I can speak about the Akuma case because I was involved in the matter.
Oh, sorry,
yes,
who is this?
I was lead counsel in Lilian Akuma against First Bank.
Okay.
So what Enan Wilson SN said was actually the argument we put forward there.
Yes.
Because if you look at Ajibola's case,
yes,
it was POPA.
Yes.
And we are saying that it is a law that seeks to protect public officers.
Mm-hmm.
It is not a specific limitation law in the nature of the limitation law of Lagos State.
Yes.
And that it would be wrong to apply it wholesale the way NIC was applying it. We made all that argument. Mm-hmm. And I still believe that that distinction should be made. But the position NIC took was that it is a species of limitation law, just like you have said. And if you look at it, before Ajibola's case, NIC was upholding the limitation law of Lagos State. And they have actually struck out cases on the basis of the limitation law of Lagos State. It was Ajibola that changed their position. And that Ajibola, in my view, was not tangible enough to throw away the limitations of Lagos State or other states for that matter. Thank you, sir.
Well, thank you very much. But don't forget, go back and read section 2 of the POPA or POPL when it applies to the state, and see whether you will find that it is not the NIC that has said so, but the legislator has indicated there that POPA is nothing but just a species of a limitation law, and whether then you can have a general brush in looking at it. But let's leave it to Taiwo to have his view. Thank you.
Thank you very much, Lane Silks, for that contribution. I think that a lot has come in, and we begin to appreciate, we begin to appreciate where we are and how far we need to go. And I'm glad that some of the justices of NIC are also part of this conversation.
Yes.
So, I believe they will take that back as a feedback. So, but very quickly, by way of reply, is on the issue of whether or not mediation would stop or suspend.
I was sorry, we're not seeing your face. It would be nice to see your face, and perhaps drop the slide.
Oh,
so it's more picture.
Thank you very much for that. All I see here is his firm. Please, there's a rule against advertising here. Please, can we take out?
Because I think somebody. Yes.
Let's see your face.
Somehow, my video out. Is my face on now? Can you see my face now?
Okay.
All right.
But please go on. Yes.
Okay. So I was going to say that on the issue relating to mediation and whether or not time will stop running or will be frozen for that period, I think Lanel Sik Kutsi did mention that, look, an exception to judicial precedent or stare decisis is a new legislation. Yeah. So I think without saying too much, that resolves that. So it's an exception to it. So going forward, that's what will be looked at, or the position that should be taken, because legislation has come to override previous cases decided by courts. Except after this stage, some decisions then will begin to follow them. But based on that legislation, it would suspend time from running. The second one was on the competing decisions of the Supreme Court. Again, Lanesik landed and said that the likely things that do happen is that when there's a competing decisions of a particular court, Superior Court of Record, and in this case, the Apex Court, right, that the lower court is at liberty to choose which to follow, but most likely they would tilt towards the latter decision. Again, there was a landing on that, and that's my view when I mentioned the Idachaba's case, right? But concerning what to do in the light of all these uncertainties, right? And as a commercial lawyer, very pragmatic and all of that, I think while we are waiting for there to be a position, and we are advising clients, or even in our own personal case or cases, as case may be, right, it may just make more pragmatic, logical sense to say, look, don't run into a situation where your case will also be used again to go all the way to Supreme Court to argue whether or not would apply, or it would be this case, the statutory limitation law of the relevant state that would apply. That it may be pragmatic for you to just put it in when you have it, while you wait for all this to resolve. But I tell you, when NIC came into being, I think it was, I'm not sure whether it was Lanel Sik, my brother, my senior friend, Adam Wilson, that mentioned that, look, the president now was very, very instrumental to some of the development. In fact, where I saw him, I thought that he wanted to revolutionize the employment law in Nigeria. But because of all of this judicial precedent, I know that he came back on some of those initiatives that he was trying to put in place at the time. So my view with respect to that POPA and where we are today is that POPA seeks to protect public officers, right? But as within the functions of their office, like decisions on whatever application made by maybe public to the office and all of those things will probably be more relevant, to POPA. But when you get into contract generally with an outsider and all of that, and you say, and you don't have a pre-action notice in your enabling statute and all of that, and you say you have to do it 3 months with me and all of that, that appears to be unfair, and that's why the court will say, look, it does not apply to contract. But if you are talking about the function of your office, right, function of your office, simpliciter, you may be protected because that's the rule of your office, that if there's an aggrieved person, there should be 3 months, right? And that it may be entertained. But when it comes to contract, when it comes to like contract with the outside world, when it comes with maybe even personal contract of service with your employees and all of that, which is a subset of contract covered already by statutory limitation of relevant state law and all of that, that should not apply. So, like I said, on the pragmatism level, I would just say, just do it in 3 months until this is settled. When to be settled, honestly, I don't know. We can only just wait and see.
Thank you very much for that insightful comments and responses to the question posed. to the observations made, for which you rightly exercise your right of reply and equally took time to further educate us more on a few areas, gray areas relating to the posers raised. I see that there's a lot to discuss, I've seen the questions, and then I want to start with that, but not without having the Director General of the Institute of Continuing Legal Education, Mr. Tobin Erojikwe, come in and say a few things, then we can go back to. So, Taiwo, please stay on. Leonard now Wilson, please stay on. Okay, please stay on. Virtually everybody, and then please, participants, we assure you that we would also unmute. So just indicate, show a show of hand if you have comment, questions, and then we will allow you to unmute and say 1 or 2 things. So we'll get back to that right away in the next couple of minutes, immediately after Tobina. Please, you have the floor.
Thank you very much. Thank you very much, Falabi. Thank you so much. First of all, before making my general comments on the presentation, I just want to say that it's a sad day for us at the Institute of Continuing Legal Education, the board and members of the Institute. Sad because, just to put it in context, the work that we do has seen us have trainings that are attended by as many as 10,000 people sometimes. And there are a group of people in the Nigerian Bar Association who have silently contributed to the work of the Institute as volunteers, and they continue to do this work every day, and we call them the MBA ICLE disseminators. This group of people consistently and constantly make sure that our training programs, our initiatives are broadcast across various platforms. They also make sure that they advertise the existence of our YouTube channel and other initiatives that we engage in from time to time. And so they are an invaluable group of people. There are so many others like the champions and the rest of them who consistently do this. We're eternally grateful to them. But my brief intervention on this aspect is just to ask us all to observe a moment of silence, because one of our disseminators lost her life to an accident some 2 years ago. At this moment, I just want to remember a dear friend, a fellow Johnny lawyer, Miss Ijoma Okoro, who lost her life in an accident. She was a member of the Lagos branch, and someone who was dedicated to the advancement of the work that we do at the Institute of Continuing Legal Education. So I want you all to remember her, and I ask that the Almighty God receives her soul in heaven. May her soul rest in peace. So thank you for that indulgence. I would just then want to say a big thank you to my friends, my brothers who have been holding forth for me through this particular series. Falabi Kuti, Senior Advocate of Nigeria, also Eku, Enam Wilson, Okechukwu Memo, the other panelists who are not here today, and the learned and the justices of National Industrial Court who also participated in the trainings. I want to say a special thank you to Taiwo Adesina for what I think was a very brilliant presentation. I know there's a lot more coming to him through the questions, and I'm sure that he will give us excellent a response to the questions as he gave to the delivery. Taiwo, thank you very much for being part of this faculty. Thank you for a well-researched and delivered presentation. And of course, we will call on you in future. I mean, the value that this particular employment law faculty brings to the work that we do is something that we appreciate extremely much. And the first series of the employment law edition was very well received. This second edition is also well received. And we encourage everybody to continue to participate in the trainings and to encourage others, considering that all that we do is to trade knowledge. So thank you very much. I'll hand over to Falabi. And Falabi, I'll ask that you also do the honors of closing the session today and indeed the series when you're done. Thank you very much.
Thank you very much. Thank you very much. Thank you very much, Mr. Tobina Erojikwe. Thank you. And we cannot thank you enough for putting this together, and then you sustained it over the years, and it's always something to look forward to, and not just in employment law, in, like I said, all the other subject areas, and for which you continue to encourage lawyers that there's a need to constantly charge the residual bank of our knowledge, that it's important to get to interrogate these things. And then we thank you, and then we pray that this will go beyond this, and it would forever remain so. It will continue to grow in leaps and bounds. All right. Let me now quickly get back to some of the questions there. And then what I'll do is that because of time, I will try to manage them. I have two sets of questions there, interestingly asked by, those are also regarded as top leaders in this area. And then I can marry the two questions because they both seem to hint at an area that we have touched on in trying to distinguish or make a distinction between the propriety of adjudicating on private employment cases in the context raised as to the actions there being caught by time, relying on cases pronounced or cases decided on public employment, specific statute made to provide or to protect public employees. And what are those two questions? Mr. Polomoy Jade has asked or has stated a matter of fact observation when it states does. Employment matters. And please, Taiwo and then Leonard Silke, Ina Wilson, please, I want you to look at this, to consider this. Employment matters fall under the exclusive legislative list. Do states have powers to legislate on employment laws, e.g., limitation law on employment cases? Now, I want you to think through it and consider same also in the context of what Max Ekobe has also raised there, a pointed observation that perhaps none of the general limitation laws of the various states and FCT specifically provide a limitation of time with respect to labor and employment. It seems they cover such matters as simple contract. Is an employment contract a simple contract that will be cut otherwise? So I want you to continue to look at that and think through it, and then let's have comment. And okay, please, is it possible you want to look at this question? And it says does. So would it be correct to say after 6 years, there is no statutory, and this is asked by Adetutu Aderemi Heri. So would it be correct to say that after 6 years, there is no statutory limitation that prevents a former employee of a private organization whose employment was wrongly terminated after she whistleblowed against a bank fraud, but was only recently able to get evidence to prove it? Can that person sue on both causes of action now? So our employment was terminated 6 years ago, because, I mean, on an account of, I would imagine, a false whistleblowing allegation or act, and she's just waited this long to bring an action because she says that she's just been able to find evidence to prove or sustain her claim in court that she was wrongly terminated, and that indeed the whistleblower, that she did was properly done. Whistleblowing that she did. So I don't know how we want to go.
But you want me to take a bite?
Oh, please go ahead.
I think I would defer to, from both the two learned senior advocates have said, both of you have come to the conclusion, and we are going to follow you, that as it is that there's confusion as what is the state of the law.
Yeah.
However, if it is a clear limitation situation, it is a strict liability issue, because if you are cut off by limitation, you are cut off by limitation. It will apply strictly. However, the way I think it was Enna who mentioned it, there's also the policy approach of the National Industrial Court. It is possible that looking at the whistleblowing policy and the principle behind it, including the statute to that effect, you notice that there is need to encourage such incidences, but will it not be caught by limitation? I think it will be caught by limitation if you go to court to challenge your dismissal, because what will determine whether it was caught by limitation or not will be at what day did the dismissal take place. And then it will be reckoned with. However, you have to also understand there's a notion in limitation that says that time starts to run when all the incidences or facts that will give you a right of action have taken place. If all of them have not, the cumulative events that gives you a right of action, if they have not taken place, the right of action has not come to fruition. So it could also be argued that it is when you get that document that you are not able to ventilate. That would be a contrary view. But the one I will stick with is that if you are caught by limitation, you will be unable to challenge that dismissal at that point.
Thank you very much for your thoughts. Truth in itself is that it's law. No one can fit all for many of the scenarios that we're faced with. I personally agree with you to an extent that, maybe when it is found that it might be a plausible argument. But to my mind, I think the more plausible one will probably be that, yes, there's an exception to even limitation, continuance of injury. So, because it's arguable that the termination, the right to bring an action to challenge termination would start counting from when the termination itself occurred. But what might be plausible or more plausible to sustain is that 6 years later, the fact that this injury has continued and continues even in the light of this evidence that should not have been. I don't know. Like I said, no one can fit all. So let's go back to the other questions asked. I don't know if they.
Okay. Folabi, let me say my bit.
Yes.
Okay. So let's assume, for the sake of the questions, that the exceptions under the statute of limitation,
yes,
do not apply.
Yes.
And that it is not a continuous injury and all of that. So the statute will be cut. The claim will be cut by the statute unless there is a way not for that statute not to apply. because when we are dealing with exceptions, whether the cause of action, you're basically interpreting the statute. But if you're saying the statute does not apply, so one of the questions was, is this not a law of a state in which the state has powers to pass? So it falls within its competence as a state because of the legislative list. I agree, yes, it does. And that is why the law cannot be wished away. The second leg to the question is, are contracts of employment not simple contracts? Or flip it, are contracts of employment simple contracts? My answer would be yes, they are simple contracts. However, because you're dealing with employment law, and because of the third alteration and the NIC Act, it is not just your simple contract. There are statutory interventions which makes it a different kind of contract. Yes. And it is the same argument that those of us who also practice in the maritime field we face. Yes. When you're dealing with stevedoring contract, and the question is it not a simple contract? Yes. Or what makes it different? The intervention of statutes into either the performance of the contract or the way the contract is construed by the court makes it different. Yes. And that is why when I made my initial intervention, I am all for the NIC saying we should be able to intervene where we need to, because like the NIC has held, these are contracts between two employer and an employee. Yes. The NIC's decision, the NIC's attitude is not to construe those contracts blindly. The NIC will intervene where the contract appears servile or unfair. So for me, I will explore, if I am faced with a limitation of liability, a limitation of action scenario, and I'm the one that wants to stop it from applying, I will explore what are the available rights that I have under the third alteration. For instance, would it be international best practice, for instance, to apply? Will it be best practice, for instance, to apply the limitation law? Will it be unfair in the circumstances of my particular case? That is the way I would be thinking. Of course, those ones situate more with employment law because you're construing employment law. You're not construing some other law. And so I look forward to a decision, either of the Court of Appeal, I think it can only be from the Court of Appeal now, where employment law is construed vis-a-vis the limitation law, and then give a pronouncement. Then I'll say, yes, the issue has been settled. Until then, alatua continua.
Okay, so if I respond.
Yeah, please go ahead, Tao.
Okay, so on the banker, I think the cold truth from where I sit is that if 6 years has elapsed from the facts of the matter is elapsed, it's sad, but it has elapsed. So the cause of action will be when the employee was let go of that job, right? I struggle to see the continuing damage that would happen. Natural thing is, if you are let go of your job, we know you also have an obligation to mitigate that damage, the honest of why you're out of job. So I think that 6 years would apply. With respect to the other question on whether employment is a simple contract and then should fall under the limitation law of the relevant states. I think if we don't construe it narrowly as employment of service or contract of service, and look at it also as that it could also be contract for service. And if you look at definition of employment or employee, and then maybe under the Workmen Compensation Act as well, it's broad. Do you understand? It's broad to include or to accommodate contract of service, the one that we are possibly looking at this point, but it's also a contract for service. Do you understand? From an independent contract point of view, for a job to be done, right? If you look at it from that angle, then you tend to agree that he would have gone to like a simple contract and can come under that limitation law for contracts generally, and that's what has happened. And I think that has probably resolved the issue of whether or not also is an exclusive list issue that should be pronounced on by, or that should be legislated upon by the National Assembly as opposed to the state. The state is not coming from employment, they're coming from contract, and they see employment contract either for service or service as an offshoot of a contract, and that's where it sits. So in my view, I don't think they've really made any or committed any offense. I don't know which other question is there. I know there's one from Adetutu. There's Mark and there's Paul. Let me look for Paul. Okay, I think I've dealt with Paul. I've made my comments on Paul's.
Okay, I mean, I think there's a clarification, which I think is a beautiful one that has been made by Israel Usmon here in the comment section. And he says that limitation of action relates to access to courts, which is subject to state limitation laws. While employment law, labor matters fall under the exclusive legislative list, which relate to substantive subject matter of labor law and employment. And that's indeed a very compelling, potent argument to make in that. So I can now quickly run through 3 questions and I'll come back to it. But just before I do that, I would the issue about continuing damage, continuing injury or continuous damage might not be so difficult to pull up if by the time it becomes a question of pleadings. We shouldn't forget that in going to court and trying to avoid a potential objection as to that the action is court, it is how skillful the draftsman puts the claim across. So, the relevance of that thought will become crystal clear if, for example, a pleading in this case is drawn up to be Mr. XYZ worked with ABC Limited on so day, he made this allegation and then substantiated or tried enough to make this to substantiate it. The company felt it wasn't enough and it was terminated. Between then and now, he suffered, he's gone through emotional trauma and all the rest. He has not been able to get any work, he has not been able to do this and all of that. And that continues until 6 years, this line down the line, he's found this and feels that he's entitled to make a claim. So I think it's a question of how the pleading is put across, and then it won't expressly be said continuing injury like that. It is a question of what to read and how it is put across so that the objection, even if it is raised, it will now be less condescend on the statement of claim, because at that point they say it's a statement of claim that the court should look at to see whether indeed this argument that will be made in response to that objection is valid or is validly made. There is a question here. If the current regime upholding best practices such as sin with ILO, beacon of light, pretends that labor is not a commodity to be bought and sold in open market, employment contract, really simple contract, straight through sensu, can we see it as a species of simple contract? Can limitation law apply? Current speaker, yeah, on that. Still relating to that, so I'll just read about 3 and then we can just have a bite. On the issue of POPA and the general statute of limitation, especially as regards litigation on title to land, will it be proper to posit that because Land Use Act 1978 is a super act and it's a constitutional matter, there is supersedes POPA on that procedure to be adopted in determining? I think I can skip this. It looks more restrictive to land. In Bedu and Iti, the Supreme Court held that the terms of an employment are to be construed by reference to, okay, that's a comment. Will an employee be compelled? Will an employee be compelled in a letter of employment as to maximum claim it can make in court in the event of breach of contract of employment? That's a question which I think we can take. Will the 3 months limitation period still apply where the public officer acted in bad faith or acted ultra-whereas his power? And I think I will address a bit of that in this presentation, but of course, if you still want to. What is your take on the position of the NICN in relying on Supreme Court cases to hold that limitations do not apply? I think this has also been discussed. Please, okay, there's a comment. Okay, all right. So I don't know. I mean, if we want to take any of the areas that I've highlighted, then we will leave it open. I see a number of hands up. I see about 4 hands, and I would call on them to please unmute and share their thoughts or ask their questions. Oh, it's about 5 hands now. There's Ngozi, Chubuzi, Cornelius, Dibia, Seidu Gumi, Abdulwasiu, Wiridi, and Henry in Kamutke. So before we ask them to unmute and ask questions one after the other, so I don't know if you have any additional thoughts in relation to the questions or the comments read.
Someone asks if, essentially, if an employer can limit his liability in the contract of employment. It sounds like unfair labor practice.
Yes.
That would be a classic unfair labor practice, and it may not stand at the NIC.
Well,
I think, and on this, Olabi will agree with me.
Well, no, I was going to say that is the position of the law. I mean, the current state of the law. But it's interesting to hear it from you because I thought you were going to say that. Of course, it's the contract of parties. And a contract, as long as it's a contract of parties, that should be the position. But I'm happy to hear that from you. Please.
Okay.
Okay. Yes, I don't know if there are no additional thoughts. So let's Ngozi Chibuzi, please unmute and go ahead. Your comment, question. Okay, if Ngozi is taking time, Captain Dada Labinjo, do you want to unmute and pose your question or make your comment? All from the back end, there is no interference or there is no problem in getting them to do this.
Sorry to interrupt.
Yes.
Maybe the other question is, I don't know whether you mentioned it. Somebody is saying, is there a limitation period within which to file an action against an employer for the payment of an employee's salary arrears?
Is it what? Say that again.
Is there a limitation period within which an employee can claim for arrears of salaries?
So
did you get that?
Yes, please go ahead.
Yes. So I was just trying to bring the question to your attention.
Yes, no, I didn't see the question, but
okay.
Yes. So do you want to have a bite or any other person want to speak to it? Limitation period within which you can bring.
It's been answered in the course of our conversation. Yes. As we speak today, is within 6 years. 6 years.
Okay.
That's a short answer.
All right. Okay. So Saidu Gumi, do you want to unmute and ask a question? Officer Tokola. I hope there's no problem in getting, because it appears nobody has been able to do this.
Is there somebody who is unmuting them? Because I don't think the participant can unmute on this by themselves.
Oh, okay, okay. Oh, that might just be what's we would need to look at the back end to see if the man providing the technical support could help unmute or to allow the participants to unmute and speak.
Yes.
Okay, whilst we're waiting for that, so I don't know, I mean, if we still want to look at some of the questions and comments, my very good friend Jeffrey Ebo, I've seen your comments. I can assure you that the slides and the papers for the participants would go around to all the participants. Just leave your email address and then this would definitely come to you. And particularly, yes. Then somebody has asked that what is POPA? Don't mind us. We were speaking a jargon that we thought was commonplace. POPA is Public Officers Protection Act. I didn't raise my hand. I would like to know if a restraint of trade clause in an employment contract for a number of years with no monetary value attached to the restraint is an unfair labor practice. Well, this is outside the breadth of what we're discussing, but thankfully, we have very able and capable hands to deal with. So a question has been asked. I would like to know if a restraint of trade clause in an employment contract for a number of years with no monetary value attached to the restraint period is an unfair labor practice.
Okay, so let me give it a shot. I think the start point for that, you know that restraints of trade generally are not enforceable, right? But the situation where it can be enforced is if the employer has shown that it has committed funds to train that employee or those employees, and there's legitimate expectation that those employees will stay. Typically, you will struggle if, and I'll come to the nature of training. Some trainings are done in-house, those may not count. If they're external and there's evidence to show that if business expended money, right, there may be a case to enforce that. But in terms of duration, if it goes beyond 1 year, you may struggle, right, to enforce it. So in terms of without monetary value, I want to believe is whether or not the firm is expending money, right? And if that's the case, that would be my response to it. So it won't be unfair labor practice if the firm expends money, depending on the quantum of that money, right, with an expectation. So let's give, for instance, I work in a business right now, and part of what I require to perform my function is some trainings abroad. And the firm sent me abroad for like 6 to 8 months to undertake that training. There's a legitimate expectation that when I come, I would at least work for 6 months or 1 year. And if I violate that, there are 2 things. And it may also be better for the firm to create an avenue where that amount expended on the training, the ascertainable amount expended on training, is an option, you know, for the employee to refund, right? Even though that's not what the business wants. But if you don't, even if you don't have that, it won't be an unfair labor practice because there's a legitimate expectation from the employer. Even the employee would know that if I'm going on this training, I'm going to do 8 months, the firm would expect me to come back and put in some month or 1 year. So typically, if it's within 1 year and a year, that can be unfair labor practice. But if it's outside this and it's much longer, the court may hold otherwise.
Fantastic. Thank you very much, Taiwo. I mean, you pretty much said it all. I mean, just to...
Can I intervene a little bit?
Yes, I wanted to say one a bit. Let me let you go. Please go ahead, sir.
Okay. You know you have precedence, so you can say and I can.
Please go ahead, sir. Please go ahead, sir. Yes.
Okay. I wanted to draw attention to the case of Aprofim Engineering Construction Nigeria Limited against Bigoret. Bigoret is BIGOURET. This is a Court of Appeal decision. And it's a very interesting decision because for some reason it has been quiet and not much noise has been made about it. And in this decision, the Court of Appeal relied on Section 17, 3, sub A, E, and E of the 1999 Constitution as amended to hold that basically restraint of trade clauses are void in Nigeria, regardless of the reasonability or otherwise of the time or the geographical continuity, as the case may be. And the reasoning of the court is that Section 17(3)(a)(e) of the Constitution, this is Chapter 2, by the way,
yes,
provides that all citizens, without discrimination on any ground whatsoever, have the opportunity for securing adequate means of livelihood,
yes,
as well as adequate opportunity to secure suitable employment. So restraint of trade clauses derogate from that provision of the Constitution. And so any restraint of trade clause that derogates from that will be declared void and unconstitutional. And this is very interesting because I think I was trying to the other day look for how many decisions of the NIC has relied on this. And I think there's just one decision that I found. I've been looking for that decision. I didn't know the question was going to come up today. I would have looked for it, but it's a very profound decision. And I think we need to take a second look at restraint of trade clauses in light of appropriate decision.
Thank you very much, sir. Thank you very much. I, before now, not aware of that decision, but one or two questions I would like to pose. The decision, when was this made precisely? Hello? Hello? The decision you just mentioned, sir.
2015. 2015.
Fine.
Yeah.
And in the judgment, is it a decision of the Court of Appeal from a decision emanating from the industrial court or before the third alteration?
Say that again.
That decision, is it based on an appeal from the industrial court or an appeal from
No, not at all. It came from the regular High Court, incidentally.
Sir, with due respect, I've not read the decision, but even as you said, as you brought it to our attention, I was almost tempted to say that that could have been reached in as in per curiam, or more importantly, there's also a need to look at in context. Thankfully, we now have decision of the Supreme Court that has now affirmed that you should always look at decisions based on the regime of the law, the regime in place in relation to the law when that decision was made. Now, we are well aware that with restraint of trade, and just as Taiwo has beautifully explained it, the restraint of trade in itself, the starting position, and there are Supreme Court position validating it. Restraint of trade in itself is an illegal contract. It is only a legal contract where it can pass the reasonability test. And what is reasonable is not even a question of this is what has been committed and this is what is expected for a year. It is always a question of fact. And the question of fact would take into cognizance a number of things. I mean, I didn't know this would come up as well, but I recall that the first time I read about this was in Sage's book on contracts, relying on some decision of the Supreme Court, where this was explained that restraint of trade recognizes that on both sides, the employer has invested or the contractor counterpart has invested on the contractor counterpart. And there's a need to protect his commercially sensitive trade secret. There's a need to protect his investment. So he is entitled to enter into an agreement with the counterpart that is invested on to say that you will be bound, you'll be tied to serve or do this within a period of time. What is important is that it must be reasonable. And what is reasonable is question of fact, because it must be reasonably commensurate with the investment. That's number one. Then secondly, where the counterpart decides to leave that trade, he is at liberty to leave. What is important is that he must pay a corresponding fee. It is only when he's held that, no, you cannot leave, that you can start looking at the context of, this is against the ILO Convention on Freedom of Contract or Labor, or is against the letters of the Constitution. I've not read this judgment, but even as you spoke to it, I was just wondering that the judgment relied on a section of the Constitution to say that this is what, there's a fundamental right. But again, that fundamental right in the Constitution also recognizes that it is not allowed. There is a corresponding section of the same Constitution that recognizes that many of these rights are not allowed. And some are subject to contract of parties. What the law is particular about, and which is, which I think is consistent with Section 6 of the Constitution that gives judicial power on determining rights and obligation, is that one party does not exercise a power over the other that seems to muzzle and restrain from carrying on his trade unnecessarily, unreasonably. So I haven't seen this judgment, but one can easily make a distinction that, number one, it came prior to the third alteration. Industrial court, the Supreme Court has now told the Court of Appeal, in deciding on
2015 decision.
Yes, it's like it doesn't matter. It could be 2020. We know how long the court's docket, Court of Appeal, is congested. So an appeal from the High Court of Lagos on labor matter in 2005 is likely to still be in the docket of the Court of Appeal.
Okay, well,
what's important is that at any time that you look at the judgment of the Court of Appeal, which is not the final court on labor, first thing distinction to make is that, is it coming from the industrial court as a court of first instance? It is coming from because if it's coming from the industrial court as the court of first instance, then we can say that the panel considered it in light of the third alteration. The third alteration is revolutionary. And again, we shouldn't forget that the third alteration starts in 254, notwithstanding whatever is said in the earlier part of the Constitution. So, it all depends.
Well, I was thinking that...
Let's look at it. Was it made prior to the third alteration or post-third alteration? If it's post-third alteration, I would say it's forceful and potent. Please go ahead.
I was thinking that for employment lawyers, employee lawyers, that they will applaud the decision and they will say the decision is, in fact, speaks to the spirit and intent of the third alteration, not the other way around, the way you're trying to make it look. Because it appears to protect employees and rather than employers. So
Leonard brother say, I know where we agree and where we depart, and I know the side of the pendulum will swing.
but it's a good thing that we go look at the decision, so we know how.
Yes, thank you so much. Yes. Great expositions. I don't know. I think this is a convenient time to close. A few minutes to 4. The paper presented today would like to have your final thoughts, and then thereafter I would hand over to Mr. Enan Wilson, SCN, to bring this to a convenient close. Thanking everyone, and that will be it. Thank you for being part of this, and make sure that the conversation continues, and we continue to interrogate this. And at the level, beyond this, at the level of the MBA section on business law, employment, labor relations committee, similar programs will be coming up in the near future, and we'll just leave links that if you want to be part of, that you can join in. And then that I will put in the chat box now, and then we'll take it further from there. Thank you very much. So, Taiwo, it's over to you.
All right. Thank you very much. I think first and foremost, I just want to thank the audience. I think we got a sizable audience for this presentation. And then also very valuable is the interventions, of the Ladet 6, as well as my other colleagues. It's been very, very in my view, educative, refreshing in some cases. And to just mention it, I used to court a long time ago, and I did for like almost 15 years. And then hearing this argument from Lanesik Wilson and Lanesik Kuti, I'm like, look, oh, are you missing something and all of that? But to be candid, I think it's very refreshing, very interesting, and I just want to thank everybody, the participants, the colleagues and senior lawyers who have made their own contributions also on this paper. I thank you all and wish you a wonderful rest of the day and the week. Thank you.
Thank you very much. Yes. So, Mr. Wilson, and to all the participants to be part of the NBA section on Business Law Employment Committee, I think a link has been sent, or it's been sent on the chat box that you can simply log in or send a mail, and then you'll be added, and from time to time you get notification on upcoming events and the papers from these sessions. Please resend, Nat, please resend the email address. All right, thank you. Okay, thank you. Okay, thank you. Time to draw it close now. I mean, just to be sure, please look into, I think it's been sent again to the chat box. Thank you. Oh, it is an email address. It's an email address, yes, not a link. Okay. Thank you, everyone. A very good afternoon.
Thank you, Alexio, and thanks, everyone. Thanks,
Thank you, everyone. Bye. Bye.
Thank you, everyone. Bye.
Bye, everyone.